Thank you for staying with us. We continue in court now, where the two Ndimande brothers who were arrested in Eswatini in connection with the murder of Keenan, AKA Forbes, as well as celebrity chef Tibz Motsoeneng, will finally be extradited. Meanwhile, back home, controversial Pastor Paseka Mboro Motsoeneng, as well as his two co-accused, are spending another weekend behind bars after their bail hearing was postponed to Monday. For more on this, including the latest developments in the Senzo Meyiwa murder trial, we are joined by legal expert at the University of Johannesburg Law Clinic, that's Elton Hart. Elton, a pleasure to have you on the program this afternoon. Maybe let's start with the Pastor Mboro case. The case of Pastor Motsoeneng involves a series of serious allegations or charges, including kidnapping as well as possession of unlicensed firearms. How do you assess the legal complexity of this case, particularly given the past incidents and the current charges that Mboro faces?
No, indeed. Normally what we come in, he's currently in court for a bail application. Now, when one looks at it, you either have a Schedule 1, Schedule 2, Schedule 5 or Schedule 6 bail application. I think for the best for him is now, I think he's in a Schedule 5 bail application, and there's 3 charges that's leveled against him: that prohibited firearm, the unlicensed firearm, and also his damage to property charge against him. And for that, I think that is already, it's like serious offenses, but one should not now confuse the charges against him and his bail application, because when we look at bail application, one needs to look at Section 60, subsection 4A to E, to see if this man will stand trial, will he intimidate witnesses, will he interfere with the with the administration of justice, and will he commit any other further offenses. And that's where the bail application is centered around. Yes, there was previous charges that was brought against him and dropped, but that we should not look at the, yes, the seriousness of the charges should be mentioned for the schedule, but not per se in the bail application as to the merits of the case. Unless he wants to speak about the merits, then the state can also bring it in.
Right. I actually want us to crystallize that point. And also given Pastor Mboro's previous 9 arrests from what's been mentioned, how significant is this criminal history, if you will, especially in the context of this current case? Could this history influence even the outcome of the bail application or the trial itself?
No, obviously the state will have to come and say, okay, there was 9 charges brought against him, but the mere fact that the state actually did not prefer further prosecuting those charges and it was dropped, it means that it lacked merit. And they cannot now use it against him to say that he has got a propensity for actually committing offenses or be in contrast or in conflict with the law. They have to now stick to what's in front of the court to say there is this 3 charges. And we feel like in terms of Section 60, he is not a candidate that fits the profile as outlined in Section 60, subsection 4. And you have to limit yourself to that. Unless Pastor Mboro comes now and says, yes, I'm this upstanding citizen, I'm that, and he speaks about his character, then the state can introduce evidence that actually attacks his character. So there's always that balancing act that has to be made when you're dealing with bail applications.
Elton, the case has also revealed issues with address verification and the possibility of prior cases being reinstated. What are the legal implications of these issues for the prosecution's case, but also the defense's arguments in matters like this?
No, indeed, to have a fixed address is one of the prerequisites for actually checking that you have got a fixed address, and it will be easy for the investigating officer to make contact with you, to trace you. In case maybe you are granted bail and you violate your bail conditions, they know exactly where to come and look for you so that they can actually bring you before court and bring the application to say that your bail has to be revoked and you should remain in custody. Now, if they cannot verify that you are a resident in a specific, it means that they don't have a place to tie you to. And that becomes then an issue to say that you don't have a fixed address. Maybe you can try and evade future service of processes that has to do with your court case, and it might then hamper the administration of justice. And that is sort of half a thing that they hook onto to say that you are flight risk and you will not stay in your trial. So it can have a bearing, but if he can bring proof that he's currently resident there, or he's got a lease agreement somewhere where he's staying, then that should then clear up the air on that issue.
Elton, another case that appeared in court is that of the Senzo Meyiwa murder trial, where we, of course, heard more evidence on cell phone-related evidence, that is. Let's speak about cases involving high-profile public figures or high-profile individuals who are involved. I mean, the name of Kelly Kumalo again coming to light. How can the legal system ensure that justice is served fairly and without undue influence from the media, if you will, or public opinion from those who are following this case?
No, indeed, when one looks at the case and what has played out in the Senzo Meyiwa case, one should always just look at it from now. What has been said about Kelly Khumalo up until this point is hearsay evidence. And they need additional evidence to come and prove that whatever is said about Kelly Khumalo actually happened. And the state in this instance, they first want to try and pin these 5 accused down to say that these communications has happened. And I think if they find these 5 guilty of being involved in the murder of Senzo Meyiwa, then they can go after Kelly Khumalo. But here it's now evidence, and already we see that Colonel Steyn was recalled to come and clear up evidence. So it already, for me, there's an indication that something is not clear about the evidence. And then also there's now talks that they want to maybe recall the Vodacom expert, that Pinky Weitlingham, to come and clear up things again about the Vodacom evidence. So already these 2 sets of evidence it's like sort of half kicking against each other, and there's certain things that one expert is saying that's contradicting what the other one or in conflict with the other one say. And for me, electronic evidence must be genuine, authentic, to be admissible in a court of law. And here already you see that evidence was taken from a PDF document, converted into an Excel document. For me already there is tempering or maybe alteration that can happen in that process. And that process needs to be tackled by the defense teams as to who can verify that when you took the PDF data and transform it into Excel data, it was not altered and those type of things. And even so, the mere fact that I think Steyn on his second appearance now says that he only had a 205 up until 27 October. Now suddenly he's talking about communications violations, and that is just muddying the water for the state. But I can see the state is trying to pin them down, and once they pin them down, they're going to go after Kelly Khumalo.
Elton, considering the high-profile nature of this case and also the case of Pastor Mboro and also these ongoing investigations that we are seeing, how does the legal system then balance transparency with really protecting the rights of those involved, particularly minors or even sensitive information?
Now, obviously, now we live in a digital age. Information is freely available. And I mean, back in the day, when a witness testifies in court, another witness is also going to be a witness in that same proceedings, cannot be inside the court to hear what that witness is testifying. Now, with television, I can sit at home and I can watch what the witness is testifying in these high-profile cases. And tomorrow I can sort of half alter and adjust my evidence that I'm going to give in line with that so that it corroborates. So that is the danger what it is. Yes, the media plays a pivotal role in actually making sure that justice is seen by the broader public, because the public wants to know. They've got a vested interest in these high-profile cases. Right. Yes, the media brings that perspective, but it can also bring that danger that witnesses can now see what the other witness testifies, and that can defeat the ends of justice now or the administration of justice to say, will we really get the truth, or will it be an amended version of what really transpired on a specific event, and in this case, on that night of 26 October 2014.
Let's also look at developments in neighboring Eswatini. The Ndimande brothers are being extradited to South Africa, also in connection with the murders of Keenan, AKA Forbes, as well as his friend Tibz Motsoeneng. Elton, what are the key legal considerations, especially in international extradition cases, and how does the ruling in Eswatini reflect these?
Now, if one looks at what happened in Eswatini, obviously there is this cooperation between South Africa and Eswatini. There's the SADC, the extradition treaties that you have to look at. And obviously these guys, they opposed the application because South Africa made an application. They sent through the evidence, the documents, the video footage, the information pertaining to what charges they want to prefer against the Ndimande brothers. And what they did in this case, and I think the KZN police task team that was on this case did a stunning job in that they did not just go after them for the Keenan, AKA and Tibz case. There was also other 2 murder cases, and murder is one of the extraditable offenses that you can be extradited for. So they packaged those 3 cases to say that our case doesn't solely rely on what happened on 10 February 2023. There was also an incident in December 2022, and I think a little bit before that. So there's 3 cases that these guys are running for. And the defense that these guys put up is like saying that there's conspiracy that's or conspiracy people that's working with the rival gangs against them to actually get them to South Africa and kill them. Yes, we've got facilities in place and the court can set certain conditions. So for them to oppose, there was then suddenly that leg of opposing the application and to say that their safety is in jeopardy. The court can say to the South African consular services, South African international, listen here, when you deal with these guys, this is what you need to do. And I think the court did very well in explaining what the conditions should be for the extradition there.
Let's speak more about that. What role do, call it, international legal frameworks play in handling extradition requests, especially when the accused have concerns about their safety or even the fairness of the judicial process in requesting in that particular country?
Now, if you want to now tackle the fairness of the judicial process, in South Africa, we've got a whole host of things that can guarantee your right to a fair trial, which is enshrined in the Constitution.
Right.
But the international framework, if you look at extradition treaties, and obviously before you can actually send somebody from one country to another, there must be an extradition treaty and agreement between the two countries as to how this process will happen. So you'll have extradition laws in that country, this law, and they will have like something that's binding the both countries. So that to say, if somebody is of South African descent, he's found in a country, but South Africa is looking for him, and he needs to be brought back to South Africa, or you can have like a foreign national, like we have with the Bushiri case in Malawi currently, that it's a Malawi citizen that committed or allegedly committed offenses here that we want to bring back. Then you have to comply with the extradition laws to say that you will get a fair treatment. And then obviously that extradition hearing takes place where the alleged perpetrators find themselves. Like in the Ndimande brothers, it had to happen in Swaziland. And once the court in Swaziland say, this is an extraditable offense and you don't have any defense in your extradition to South Africa because the reasons you are advancing is not reason enough for you not to be brought to that country where you are looked for to stand trial with. And the one in Malawi with Bushiri is a little bit different because it's now a Malawian, and the Malawian courts are saying that, but they want South African witnesses to come there and testify because they feel like their citizen will not be treated fairly. So that was how these frameworks work, and you can see from a place or from country to country, it differs, and it also differs how the magistrates interpret it. And obviously, it's subjective decisions, although they might say it's objective decision. There is some sort of a little bias built into the systems to say that I don't think you guys will treat my citizen fairly, so I'm not going to send them that way. And a similar case was that one of Shireen Divani also that we had a while ago.
But how might the outcomes of high-profile cases such as the ones we've discussed influence future legal, especially proceedings, and also the public perception of the justice system here in South Africa?
I think the old saying that everybody would say is like justice delayed is justice denied. But also I see that it's like you look at a situation like this, these high-profile cases, it's normally protracted litigation that happens. And because the people who's involved in the litigation process normally has money on their side and they can actually protract and use all the legal avenues that's available in the book to test and actually make sure that they can sort of have challenge whatever evidence is there. But the ordinary man on the street, he doesn't get these liberties because he doesn't have the money, doesn't have the legal teams like this. And people in the general public will say, but if you are a public figure, you get preferential treatment, you get all the special attention and those type of things. And there's various cases similar to these ones, murder, that is in courts on a daily basis, and the courts quickly run through them with the evidence and everything, not saying that they are neglecting the processes, but that is just the perception that people get. If you have money, you can sometimes get away with murder if one wants to use that plain English. And if you don't have money, you might end up in jail. And that is what the perception is on the street.
And very quickly, Elton, in your opinion, what are the most significant legal but also ethical challenges which are faced by the legal professionals when dealing with such complex and high-profile cases that also capture widespread media attention, just like these ones?
No, normally the ethical dilemmas is that you might find that you get underhandedness in the system, and it can be from the investigating officers, it can be from the prosecution authorities, it can be from the defense counsels, that they are not open with the court to actually tell the court really, or put the evidence before court to say what really happened and to place the court in the best position to make the best decision. And that is normally where you as a lawyer need to say that although I have a client I am an officer of the court. The state prosecutor's duty is not to convict every person that gets into the box, but to make sure that justice prevails. So if the state is in possession of evidence that exonerate a person, then they must also tell the court, listen, yeah, we've got this evidence, and it says it's not this man. That's the role of a prosecutor. And the investigating officers, because they have these tools at their disposal, they need to use that tools with sensibility, fairness, and responsibility to make sure that they don't victimize people just because I don't like your face or maybe we had a bad, but really make sure that we use the state's resources to actually find who really committed an offense and then bring them before book. And there is these things in the system that sometimes the state's resources is directed at the person who really did not commit the offense, and only after years you find out they didn't commit the offense. And the prosecutors that's maybe sort of have bias in the sense that say, I'm just going to go after you because this is what the investigating officers say. Or you get defense lawyers that will just spin a story to the court which they know is not true, and they will try and make the court believe that that is what. And for me, as a lawyer, you need to always make sure that if you know your client has committed, you need to work maybe with technicalities and other things, but never get to a point where you put the client in the box to say to court, I have not committed this offense.